This bill would make critical changes to the Minority and Women-Owned Business Enterprise Program. These changes are based on the 2016 Disparity Study in order to meet the constitutional requirements established by the United States Supreme Court. The study found a statistical significant underutilization of available minority and women businesses and provides support for the continuation of the MWBE program. This bill would authorize a new increase of personal net worth to be established to additional participants to the program and require a new disparity study to be undertaken and completed within the next 4 years. This bill will also require new disclosures to be published regarding waivers within the program by contracting agencies. It would also create and authorize a workforce diversity program to increase the participation of minorities and women in the workforce. It would increase the time to certify, as well as extend the provisions of the entire MWB program for 5 years until December 31st, 2024. Mr. Speaker, I would just like to take us a little bit back on why we're doing this and what was the purpose of this whole program. So first, the Disparity Study's chief purpose is a tool to determine whether any race or gender-based disparity exists in local government contracting, okay? And this study has been guided by the United States Supreme Court's 1989 decision in City of Richmond versus J.A. Croson. Now, in 1983, the Richmond City Council in the state of Virginia adopted the Minority Utilization Plan, which required government-supported contractors to set aside 30% of its subcontractors to one or more minority business enterprise. And that was because the city was overwhelmingly majority minority. But the contracts awarded to the minorities were minimal, so there was a disparity there. The city then adopted the plan after studies suggested that very few contracts were awarded to MBEs despite the city's large minority population. Now, the J.A. Croson Company, which lost its contract because of the 30% set aside, brought a suit against the city. Now, the question is, did Richmond law violate the Equal Protection Clause of the 14th Amendment? Well, the equal protection of law usually has been the civil rights reference of communities of people that have been marginalized, whether race, gender, age, sexual orientation, religion, ethnicity, and so forth. But, Mr. Speaker, you have to understand that it's very funny how every time there is a push to reform or to remediate or to repair and affirm past discriminatory practices that have kept people like minorities and women from being on an equal playing field, there's always been a challenge. You know of the landmark case, Region of University of California versus Bakke, okay? Where Bakke, who's the respondent, sued University of California because there were 16 seats set aside for Black medical students. And as a result, he alleged that he was denied admission because of those 16 seats that were set aside, and that violated the Equal Protection Clause of the 14th Amendment. And it continues with other cases like Adirant versus Pena, where the Department of Transportation was sued because a contractor was not given a bid, was not given the lowest bidder, and it went to a minority contractor. In 1989, a very notable Supreme Court case, which we just mentioned, which is the Richmond versus Croson, ruled that the city could not ask its contractors and subcontractors to set aside 30% of its contracts for MWBE. And the issue was whether a state may be enacting an affirmative action plan without the support of a race-based measure exacerbates the effects of the past discrimination. In other words, we cannot, the Supreme Court ruling said that we cannot set aside anything if it was based on past discrimination. we have to prove that the discrimination is continuing. So the court opined that evidence of a pattern of individual discriminatory acts can, if supported by appropriate statistical proof, lend support to a local government determination that broader remedial relief is justified. So, this is where the disparity study came. The decision of the United States Supreme Court in Croson changed the legal landscape for business affirmative action programs. The United States Supreme Court case and subsequent case law altered the authority of the state and federal government to use state and federal funds to institute remedial race and gender-conscious public contracting programs depending on the statistical findings of the disparity study. 4 years ago, I was appointed as the chair of the subcommittee of the oversight of the minority and women-owned business enterprise. And this was in April 2014. Since then, I have done a lot. I have worked with my colleagues. I've been an advocate. I've been a legislator to address the inequities and the disparity of our city and state's economics. And with the support of the Speaker, majority leaders, my colleagues in both houses, we've been able to raise the visibility of the issues that affect minority women, small business owners, a group, again, that has been continuously marginalized, stripped of economic opportunities for decades. And together, we have pushed a button on issues. We introduced a number of legislation, of which many are incorporated in this MWBE Omnibus bill, a step in the right direction that can transform lives, economic inclusion, economic equity, economic diversity. It took a lot of work for years to get people to be on board, understand this issue, understand that money is very important to our communities, understand that how our tax dollars can be rightfully allocated back to our communities, which in turn would create jobs. So, Mr. Speaker, we still have a lot of convincing to do, because just like in the landmark case of Regent of University of California versus Bakke, where 16 seats were allocated to Black medical students, that was the focal point of reverse discrimination. Again, never mind about the other 84 seats, which were given to white students, and many times through legacies, endowment donors. They were never challenged. Those 84 seats were never challenged, but the 16 seats were challenged. And that's what we're dealing with today. Just like these aspirational goals were set to level the playing field, we talk about 30%, but we still have people, we still have companies who are challenging the 5%, the 10%, the 30%, just to get to an equal playing field. It doesn't matter. Racism, sexism is real. It's real today. And still, many of us, Black people, still have been waiting for their 40 acres and a mule. And what happened to that? What happened to our 40 acres and a mule? Well, we were told that because of the Reconstruction era, we weren't issued land. We were supposed to focus on wage reform. So when we think about this, let's think about the population. Let's think about the majority of the tax-paying residents who are minority and women in the state of New York, who are the majority in the city of New York. Never mind that these businesses are feeding off the tax dollars that grant them monetary profits that have been produced by the blood and sweat and tears of these same minorities and women. But when we say 30% aspirational goal, it's a problem. 30% aspirational goal in a state that has more than 50% minority of women. 30% aspirational goal in a city that has more than 85% minority of women. That's a problem. Most of my discussion with trying to reason with prime contractors has been around the constitutionality, the 14th Amendment, reverse racism, reverse discrimination. Mr. Speaker, we have a long way to go. I hope that all those that has partnered with us, the prime, the sub, the MWBE stakeholders, can see that although it's a fight, we're making progress. And this bill certainly shows and displays the progress that we've made since this program has been instituted in 1988 by Governor Cuomo. Again, let me reiterate, this bill here will address capacity issues, workforce issues, transparency around how we give out waivers and so forth. It would extend the program for 5 years. It would increase a personal net worth from $3.5 million to $15 million as the floor. That personal net worth was keeping a lot of MWBEs out the program due to capacity. So now we're going to invite these available, willing, and eligible minority women business enterprise into the program to take on bigger contracts. This bill will also increase the discretionary spend from $200,000 to $500,000. It will publicize waivers. It's supposed to shorten the certification period. And we're going to keep the governor accountable because that has been one of the single most important issue, the certification process. It's too long. On average, on the state, it would take 2 years. 2 years. That is ridiculous. We also, again, are proposing that the next disparity study will incorporate the Native American tribal nation. Again, something that our majority leader, Crystal Peoples-Stokes, has been working on. And the biggest thing, now we get to implement workforce goals, employee goals, because even in our workforce-related areas, construction-related areas, we do find a disparity. And the disparity study showed that, again, minorities and women are not being hired. That's a problem. I want to thank Mr. Speaker, Carl Hastie. I want to thank Chair Titus, my colleagues, in particular Assemblymember Wright and Assemblymember Blake, who negotiated this overnight. But I really want to give a special thanks to Majority Leader Crystal Peoples-Stokes. She started this program. She was the first chair of the MWBE Oversight Subcommittee, and she took it a long way. She had handed me the baton, and I want to thank her for having a vision many, many years ago. I would like to thank the governor and the team for coming to an agreement after battling it out for several months and all the hard work that was put onto this. I want to thank my colleague in the Senate House, Senator James Sanders Jr., for being such a great MWBE partner in crime. And I want to thank all the advocates for their input, the meetings, the workshops. You know who you are. Thank you. As we move forward, it is imperative to form alliances. We have to keep at the forefront of our minds that we are all part of one single garment, and that an injustice to one is an injustice to all. Desmond Tutu said, "A person with Ubuntu, which means togetherness, is open and available to others, affirming of others, does not feel threatened that others are able and good, for he or she has a proper self-assurance that comes from knowing that he or she belongs in a greater whole and is diminished when others are humiliated or diminished when others are tortured or oppressed." Let us move forward together. Let us affirm each other. Let us collective successes not be at the expense of another oppression. Mr. Speaker, I urge everyone to vote in the affirmative in honor of the 14th Amendment, the Equal Protection Clause.